Is this a better level?
Yes.
Okay, so we, due to the closed captioning as well as the videotape, we're gonna have to stay behind the podium and, although I prefer to come out and walk amongst the people, but in just a few moments, just about 30 seconds, we're gonna get started. So if everybody could settle down. For those of you that are here for credit as a real estate professional, the sign-in sheet will be passed out momentarily. Ms. Ramona Collette, who is going to be working with us to do the second part, she's in the back raising her hand. She's going to be helping and assisting to make sure that everyone who did register for the real estate professional credit can sign in. The sign-in sheet will be passed around. Now, this, as you know, as you can see from the guide and outside the door, this is Renters' Rights 101, which is an introduction to renters' rights within the District of Columbia. As many of you know, the District of Columbia has some of the most protective tenant rights in the entire country, and also some of the most complex. Now, our program today has been broken into two separate parts, part one and part two. The program, the guide that you were given covers both of those parts. So there's just one booklet. Don't think you're missing one for the second one. Our program today is going to be delivered by our attorney advisors from the Office of the Tenant Advocate. Myself, I am William Zachariah Mundy. I've been working at OTA for about 5 years now. The first part of the session is going to be delivered by Harrison Meiji, who's an attorney advisor who's been there for a year and a half, as well as Sean Trainer. They both started at the same point. There are two of our newer attorney advisors, but they're both very experienced in the housing field. And as if you were watching the video today, you'll hear their name mentioned multiple times by some of the tenants that were testifying to the good work that both Harrison and Sean have done so far. So, just briefly, Renters' Rights 101, as I said, is an introduction to tenant rights in DC. The Office of the Tenant Advocate was created 10 years ago. For 10 years, we've been an independent agency of the District of Columbia government. We assist tenants by both providing free legal advice as well as providing legal representation in limited circumstances. Today's program is going to be focused on the law and focused on what rights you have as well as what sort of red flags tenants should look out for. And for our real estate professionals, if you're assisting a tenant and acting as a rent broker and trying to locate housing for individuals, it's red flags that you can also look out for. Or if you also happen to represent landlords, then it's something to make sure that your landlord isn't doing, because it may be something that would scare off prospective tenants. So even though this is geared towards tenant rights and from a tenant perspective, everything that's a red flag for a tenant would certainly be something that you as a real estate professional would want to steer away from as well. So as you can see, our program is broken down into 14 different bullet points, essentially. Through the first session, we're going to make it all the way through rent control. So it's going to deal a lot with what are as a prospective tenant or as a landlord that someone's applying to, what are your rights and responsibilities. When we go through disclosures, making sure you're properly licensed, and then getting to security deposits and rent control. As you know, DC is one of the few jurisdictions in America that does have rent control or rent stabilization. And you're going to hear a lot about that from Sean after Harrison starts us off with the beginning, applying for rental housing and disclosures. So Harrison, please come up and take it away. Oh, and just as a final point before, sorry to get you antsy, just as a final point, so we want to focus, if you do have questions, one, we want to limit questions as much as possible because we do have a lot of information that we're going to try to get you, and we already are starting about 5 minutes late. So if you do have questions, please focus them specifically on a clarification of something that we said that may not have been clear. But if you have questions about your specific legal issue or a legal issue for someone you're representing or maybe your tenant association, the legal clinic is really where to go for that. And that's right down the hall. And it will be open until 4:30, but you should go talk to them and try to set up an appointment if that's what you're seeking. But if you do have generalized questions to clarify, we hope that there'll be time at the end for that. And with that, Harrison's going to take it away. So thank you all for attending.
Thanks, Zach.
All right.
So Zach just gave an overview up here of the topics that we're going to be covering.
That's Ramona, yeah.
All right. As many of you may already know, the first step towards renting an apartment is, well, the landlord often asks that the tenant fill out an application. The application asks for various personal information. However, there are legal limits to what they can ask in certain circumstances. So besides also asking for a non-refundable application fee, the landlord can ask for a credit check and a landlord reference and also an employer reference. There are limits to the credit as well as a criminal background check. The law has actually changed very recently in DC now with housing accommodations that are of a certain size and above. There is what is called ban the box, meaning it is illegal to ask a tenant on the initial application about their criminal history. If everything else checks out and the landlord wants to make a conditional offer, at that point, the landlord may ask for certain information about a criminal history. It can be very fact specific, so please, I urge you to seek advice if you're a landlord or representing a landlord before just simply asking for someone's criminal history on an initial application.
But you can do it a credit and a criminal.
No, they cannot be done simultaneously. You can ask a credit question as part of the initial application if you're going to like what. But as far as nowadays, this is a very recent development in the law for buildings of a certain size. I don't have the exact figures in front of me. I'm just saying, be very mindful of that. Now, there are some provisions that are allowed in certain circumstances. For example, co-signing, someone has spotty credit. However, while a landlord may prohibit a co-signing, they can't be doing it just for people who are students. For example, a landlord thinks to themselves, oh, don't want to rent to students, let's figure out a way to not have to do it. I just talked about criminal record screening. And if there is a holding fee, be sure to ask for a receipt and confirm that the fee is refundable. Now, be sure to look through the unit that you are actually going to be occupying, not a model unit, not just pictures online. Famous last words, oh, but it looks so pretty on Craigslist.
Excuse me, one last question about, so when is it that they can ask for a criminal?
I don't have the details right in front of me, so I can just tell you that if it's buildings of a certain size, it can't be in the initial application. Yes?
Hi, is there a legal limit on the size of an application fee?
Not to my knowledge. I'm going to say this, if it is high, common sense should dictate, be very careful about paying it before realizing, just before understanding it. Right? As I just said before, be sure to look around the apartment before signing on to it, and just, there are, word of mouth can sometimes be perfectly fine, but again, just always be mindful. And as I just said already, do not rent a property or sign a contract for a property that you haven't seen before. Be very careful that's something that is too good to be true. Leases that have excessively formal language that are not understandable to someone who even has a college education. Anytime that the landlord asks in advance for you to wire money, and also for addresses that do not exist, please feel free to check the address. And you know what? Many people in the community don't realize you are free to call the Office of the Tenant Advocate to look up if an address exists, or I'm thinking of renting somewhere, but what the landlord is asking me just sounds wrong. So for example, the person who asked about the application fee, even if the amount in of itself might not be, it might be high, please feel free to ask for other information, because it definitely would be a red flag. Yes, sir?
What's a good range for a reasonable application?
Reasonable, we could talk for hours and hours on what reasonable could mean. Honestly, I've seen application fees be as low as nothing or as high as $100. I really don't know.
Sometimes they're the first month's rent.
That is not the same as an application fee, and that would, and actually, but when we're talking about a holding fee, be very careful if they're asking someone to pay up front. And then, we're not there yet, but when we get to security deposits, there are limits on what can be asked for up front. But that is not the same as an application fee, which really, it's not supposed to be an opportunity for the landlord to make money, it's to run a credit check. But, that's not, just because it's high doesn't make it illegal. All right, this step is extremely important. All housing providers, and that also includes tenants who sublease, must have a business license in order to be able to rent out the unit. It is a basic business license, BBL, issued by the Department of Consumer and Regulatory Affairs, DCRA. A very helpful website address. If any of you are following along in the book right now, please circle PIVS. It is a very important site to verify information about a landlord. Again, tenants, prospective tenants, if you want to know if your landlord has a business license, please feel free to call our office. We're happy to look it up. It's very quick, but it can be very useful when assessing. Okay. Have they been able to hear me?
Yeah.
Okay, good. All right. Oh, at the bottom of the page are various code citations to where this information is. All right. While every unit must have a basic business license, rather the landlord for the unit, even if it's the sub-landlord, must have a basic business license. Another document that may be required, except for single-family dwellings, is a certificate of occupancy, a C of O. That is something else that we can check on PIVS about. And finally, this is a step, even whether or not the unit is rent-controlled or exempt from rent control, it must be on file with the Rental Accommodations Division of the Department of Housing and Community Development. And currently, the best way to verify whether or not a unit is rent-controlled or exempt from rent control is to call that number that's on the screen right now. 442-9505. Now, please be very careful though. Unfortunately, there's some misinformation that goes around that people get overly eagle-eyed if they find out that a landlord does not have the proper business license or doesn't have the correct paperwork. It does not mean that the lease is unenforceable or that it is void. When a person is signing a lease, it is a contract. And so, now, we're going to move on to now what a landlord is required to disclose as part of the application process. The basic business license number, the registration or claim of exemption, whether or not the unit is rent-controlled or exempt from rent control, the certificate of occupancy, if applicable, the amount of rent that is to be paid, and in the absence of legislation that actually says, earlier, if you were at the lunch, you heard Attorney General Racine talk about rent concessions. Currently, people can debate about the legality of them. When you look at the rent for a unit, make sure that you know if that is the full out-of-pocket amount. Make sure to ask if there is a concession, if what you're being asked to pay is discounted, if it can go up. Just ask questions. Be very careful about that. Yes?
Yeah, the rental company, I've been renting since 2005, still on my original lease that's updated for more money regularly.
Okay, ma'am, for a specific question, we have to ask that you either save that to a break or you can also ask in the legal clinic. Another disclosure is the presence of indoor mold or in a prospective unit or in a common area unless the mold has been remediated by a licensed professional. All right.
So how do you know that they're telling you the truth? Can we look on the web somewhere and find out if it's been remediated or what?
Unfortunately, not all disclosures are as robustly verifiable as some might wish. This is what the law says they're supposed to do. Now, there are further disclosures that apply in a rent-controlled unit. If there are any pending petitions that could affect the rent for the rental unit, if a tenant is complaining that the rent being charged is not a proper amount, or if the landlord is trying to get the legal rent raised, that needs to be reported. If there have been any housing code violation reports issued by the Department of Consumer and Regulatory Affairs within 12 months, or for any violations that remain unabated. And there's also a pamphlet about by the rent administrator that explains the requirements for rent increases. Now, PIVs, I will mention PIVs a lot, does not necessarily detail what violations may have been found, but it is reported that the housing inspector has been to the unit. So if a tenant wants to know if there's been a lot of history with the housing inspector in the unit, they may be able to get that information off of the PIVs, and again, that is something that we can assist with.
Excuse me, how far back would the tenant be able to go to obtain that information? I mean, would someone be able to go back maybe 15 or 20 years ago?
It all depends. The thing is, it is an indicator. It's not necessarily exact. There are some things that might not get reported. There may be different protocols for when something goes up online. And again, that's something that may be addressed with the Department of Consumer and Regulatory Affairs. All right. Now, additional disclosures to new and existing tenants. Certain portions of housing regulations, when you sign a lease, there's sometimes many pages of extracts from the regulations. And also, if the unit is rent controlled, the last 3 rent increases for the unit and why the rent went up. There are also further disclosures about environmental conditions, including protection from lead, which is issued by EPA, HUD, and Consumer Product Safety Commission, and also the DC Department of Energy. Now, I mentioned the lease before, and that is a contract. A tenant and landlord relationship is established by a lease, which is a contract. And there are rights and obligations that come from both sides. Now, a lease does not have to be in writing, though it is probably a good idea for it to be in writing. And if you sign something, the landlord is required to provide you a copy of it. The landlord may not change the terms of the lease without the tenant's agreement. And a very unique provision in DC law is that when the initial lease term expires, the tenant has the right to continue the tenancy indefinitely on a month-to-month basis under the same terms, except for lawful rent increases and also for the minimum amount of time that a tenant has to give before they move out. So even if a tenant signs a 1-year lease that says that if the tenant is going to be moving out at the end of the lease term, that they need to provide a 60-day advance notice. By the way, for that to be valid, among other things, the landlord must give a notice of a rent increase 75 days. The tenant is supposed to have some time to know what they would be signing up for. But once the lease goes month to month, that provision will automatically become a month. So the idea is that the landlord has, the tenant has the same amount of time to decline a rent increase as the landlord would be allowed to impose one. So if the landlord says your rent's going up next month, well, the tenant would also have the opportunity to say, I'm out of here.
Wait, excuse me, isn't there an old lease that has changed, like a lease prior to 1982? Hasn't some modification been made to those leases?
Okay, that's an interesting point. If the law changes in the meantime, if the lease is month to month, that will be read into the lease. In general, if you have signed a lease and the law has changed such that it might impact something in your current lease, please seek legal advice. Please call us or call an attorney before you either assume or not assume that it doesn't govern that. Now, some important lease provisions to be aware of. And this goes without saying, please read the lease before signing it. A very common provision that a lot of people don't realize is for group houses or when you have roommates, joint and several liability, meaning everyone who signs onto that lease can be held individually and group liable for everybody. The amount of rent that's due at move-in, so for example, first month's rent, when the rent can be increased, as well as when the rent is supposed to be paid, and payment methods, late fees, which are governed, which there is a law that has come into force a few months ago. And furthermore, what are the penalties? I said that already, sorry. Any fees in addition to rent, if the place is rent controlled, there may be the fees, there are regulations on the fees. And another thing that is very important is the landlord paying for utilities, or are you responsible for them? And that can include water, gas, electricity, trash, climate control, as well as yard maintenance. Another provision, are the tenants allowed to sublet? That's another thing to be mindful of. And also, move-out notification. When do you notify the landlord of moving out, especially in the initial lease term?
Excuse me, are we gonna discuss subleasing in this?
No, we will not.
That's also something you would take up?
Well, actually, here, if you want to sublease to someone, that actually makes you a landlord, and I'm not sure if the legal clinic would address that issue. That may be something that needs to be addressed with a private attorney.
Is that a DCRA question possibly?
I couldn't say. One option that you have if you're a landlord is you can call the number for the rent administrator, which is 202-442-9505, and ask to speak with the HPO, the Housing Provider Ombudsman.
Ah.
Now, beware of leases that have blank spaces. Don't treat it like a blank check. Please write in not applicable. If it says that if you can't find the landlord's contact information, that's very important. Many times, unfortunately, people call to ask how to find where their landlord is. Also, look at excessively high late fees and other fees. Currently, late fees are capped at 5% of the monthly rent. And also lease addendums, which include house rules. Those can sometimes be changed. For example, a favorite example that I like using is if your apartment building has a roof deck and you had to reserve it 3 days in advance. If they want to change it to you have to reserve it 4 days in advance, that might be something that they can do, even if that's technically varying from the term. Yes?
So if they hand us a big list of house rules and ask us to sign off on them, if we sign off on them, are we, as this indicates, changing our lease?
Possibly. You're certainly changing what you've agreed to. The bottom line is, even if it might not be enforceable, never sign anything that you don't feel comfortable with, that you don't understand, that they say, oh, you don't need to worry about that. Always feel free to call and ask questions. Right away, if someone discourages you from reading it, it's a red flag. Yes?
says in it that they can change, say, house rules
Uh-huh.
with 30 days notice, and then you can get out if you don't like the new rule. Is that good?
That is a very good question, but it's unfortunately very case by case. The law unfortunately does not distinguish very clearly between what must be in the lease versus what can go into a house rule. So if you have a question about a house rule, I strongly urge you to seek clarification about that.
And from whom would we get that clarification?
If you're a tenant, you can call the Office of the Tenant Advocate and we will try to answer. Yes, sir?
I should ask when you were saying about the landlord disclosure. Do they legally, right, if they want you to give them certain documents when you move in, do they have to disclose what those documents have to be or should be in writing? Instead of just saying, okay, you need to show me this. You know what I'm saying?
Again, it really depends. It's very fact specific. I do know that in certain situations, before running a credit check, there may be rules that have to be followed per the Federal Trade Commission. For example,
No, she's saying, well, no.
okay, sir, I apologize. If it's an individual issue, for the sake of time, I am gonna have to move on from
No,
that.
I'm just saying, you got a right to ask for a birth certificate, is what I'm saying.
Again, that is very fact specific. If there's no law that says that you can't, now also, just because you can, doesn't mean that you should, and frankly, if a landlord is asking to see my birth certificate, I may ask myself, do I really want to give them my business? I mean, why do they need it? At the end of the day, the customer is allowed to say no and take their business elsewhere. I realize that with affordable housing being scarce, that's sometimes easier said than done, but really, if this won't say it in any law book, if you feel uncomfortable, don't do it. Ask questions first. Now, some other lease terms that are important to be aware of. Even if the lease says that you cannot be charged a late fee until you are 5 days late, and that's the governing law now, even if you can pay without being charged a fee, that is not a license to pay late. If you pay constantly late, your landlord can take you to court for chronic late payments. How long for chronic late payments? How late does it have to be? It depends. Theoretically, if a tenant pays rent 1 day late for 5 months straight, the landlord may take them to court for that.
And what would they win?
Yeah. Now and it depends. And then finally, some other provisions where it says that a tenant is responsible for certain maintenance tasks, like is the house manager, or if the tenants have to find new tenants to replace them, or still be held liable, meaning a group lease where everyone is joint and severally liable. Again, make sure that you understand what you're signing, what you are individually responsible for, and what you can be held responsible for, even if you are innocent, but someone else does something else that they shouldn't be. Now,
One last question about the grace period. So if someone has lived someplace for 20 years and on occasion, always, like for 5 months out of every year, 5 months in a row, for 10 years, has paid as, in that grace period, could they be evicted? Or can you not?
honestly, it ultimately is going to depend on what a judge decides, and that's really not something that I can give an answer to that's going to satisfy the group. Now, there are some clauses that are unenforceable even if the tenant signs. However, again, please do not sign a lease that has such provisions in it. Please demand that it be crossed out. For example, the landlord or the tenant may terminate the lease anytime for any cause. For example, I don't like the scarf that you're wearing. Unenforceable. The tenant says that, oh, I don't have to see the property, I admit that it's habitable. Can't do that. Goes on to the tenant. The tenant says, oh, that they acknowledge the right to live in squalor. Illegal. Not an enforceable lease provision. You cannot waive the housing code. You cannot waive the right to be given judicial process, meaning that the landlord has to take you to court to sue. if they want to evict you. If you commit any lease violation other than for non-payment of rent, the landlord must give you a notice to quit, which is a fancy term for basically a shake off or a ship out notice. And then also, it is unenforceable to waive a jury trial, to waive rights under the Tenant Opportunity to Purchase Act, which will be discussed later in detail, allowing for someone else to confess judgment, allowing the landlord to say that they don't have to provide basic maintenance, that the landlord is not withheld responsible for negligence, and also bankruptcy and foreclosure can terminate a lease. It does not under the law. And also assignment of attorney's fees notwithstanding court determinations. Again, even if these clauses are unenforceable, do not sign a lease that has them. Please seek guidance. And then there are some clauses that might not be illegal, but are certainly something to beware of. Saying complex arrangements about payments of utilities. I've seen leases where the landlord will cover utilities up to $100, but then afterwards, the tenant and the landlord split percentages. Complicated, probably not a good idea. Require that the tenant has to take responsibility for any furniture that was left by the previous tenant. Clauses that talk about immoral or annoying behaviors. This is pre-signing a notice to terminate the lease at lease execution, and also making it very complicated to sublease. I will make one comment about subleasing. A landlord is allowed to categorically forbid subleasing, but now, under the law since February 2017, a lease, if the landlord is going to allow case-by-case subletting, for example, they do have to state what their criteria are and make them available on request. They can't just simply say, because I said so, it depends on what side of the bed I wake up today, or whatever. And do we have time for some questions at this point, or should we move into the next section?
We'll probably move into the next section.
Okay.
If you're a realtor and you haven't signed in, please raise your hand and I'll bring it around to you.
All right, and with that, I will turn it over to my colleague, Sean.
Hi, everyone. So, moving right along. Moving right along. Moving in. So, a couple of the main things to be aware of before moving in. A huge one is just doing a walkthrough of the unit at a time when it's vacant. I realize that many times it's much more convenient for the landlord or the property manager to have you move in immediately after someone moves out. Leases are often signed in this city well before people are moving into their apartment, especially if you go to places like Georgetown, where a lot of students are coming in each year. The problem with that is you don't know what the condition of the apartment's going to be when you get there, and you don't know when you move out what the landlord is going to try to take out of your security deposit. So take pictures of the condition of the apartment when you arrive, regardless of whether you're subletting and other roommates already live there, regardless. Take pictures when you arrive. And beware, going back to talking about terms in leases, speaking of move-in, beware of terms that warrant, that the tenant warrants, that the apartment is safe and habitable. If you're signing a lease that says that the tenant, and a lot of them say this, that the tenant warrants that they've inspected the apartment and found it safe and habitable, and you've never seen the apartment, you're being asked to sign your name to a lie. And even if that's not going to be upheld in court, and often it's not, if you can demonstrate that you had never seen the apartment and this was just a take it or leave it, I have to somehow promise to you that your apartment is up to code. You don't want to be signing your name to a lie. It's not going to look good if you do end up in court. It's not the position you want to be in. So be aware of that language. It's very, people find it confusing, I think. I think sometimes they think that because it says warranty, the landlord's making a promise. No, if it says the tenant warrants the apartment is habitable, you're promising the landlord it's habitable. which is kind of a silly thing to do if you haven't seen it. We have a move-in form that we recommend people use for doing a checklist of the condition of the apartment when they move in. And yeah, take advantage of technology. Smartphones are great. You don't necessarily need a super high quality picture to make your point if something's obvious. Although on the other hand, if it's something that is hard to see, a grainy picture of Bigfoot doesn't get you anywhere. Yes?
Can I ask you something, since you talk about smartphone? I want to know, I had several people look at me and say, we don't take Section 8 vouchers. And that's not what you told me the first time, so can we put a tape recorder, can I use a tape recorder without telling her about it?
So
Is that against the law?
That's a very specific question, and I don't want to get into answering specific scenarios just because of the lack of time. I will just in generality say, A, that you can't discriminate against people in DC based on source of income, including that they're on a voucher. As to the legality of recording someone without their consent, DC is a single consent state, but I'm not a privacy lawyer, so I'm not going to advise you on whether to record someone.
Well, I thought it was
So,
legal. That's
take,
And it might very well be, but we're,
but I am not an attorney who specializes in that area of law. I'm not going to advise anybody on whether to do what in some jurisdictions is a crime.
Yeah, I
As an
wasn't
aside,
sure.
I've recently been advised that, by an attorney, that I can do that as long as I'm part of the conversation.
So,
And until they
but-
say it makes me uncomfortable, and at that point, you cannot do it.
That may be so. There are a number of areas of law that are fascinating that we could talk about today. But we're going to stick with landlord-tenant matters. So these are just some principles that really restate what we already talked about. Don't accept occupancy of a unit that's uninhabitable. Even if it forces you to change your plans, if you show up and a place has ceilings that are 4 feet tall, has a foot of water on the ground, is covered in mold and mushrooms, these are not conditions that DC thinks are fit for human habitation. And by the way, if you do sign a lease and you show up and the place is uninhabitable, not just because there are cosmetic housing code problems, but because there are problems that make it truly dangerous or unhealthy to be in the space, there is a provision in the DC Municipal Code of Regulations to void your lease and walk away from the lease, even though you've signed it. Now, it's not something I typically advise people to do. People usually think that their apartment is a lot more, if they're unhappy with it, a lot more dangerous and unhealthy than a judge is going to think it is. But it is there. It is a tool that's available to you. I would advise consulting with a lawyer before taking that step. But just because you signed a contract 6 months ago on a place you hadn't seen and you show up and it's a dirt hole, that does not mean you have to live there. So, security deposits. There's a couple of salient points. One is that the security deposit has to be deposited in an interest-bearing account. Now, there's not a huge amount of enforcement of this. The impact, if a landlord doesn't put the security deposit in an interest-bearing amount and it goes to court, is going to be that the court is going to impute some interest to it based on the account it should have gone into. Okay, so your landlord should be putting it in escrow or savings or something like that. If they're not doing that, they're not going to be dragged away in chains, but they are still going to owe you interest on it, whether they actually received interest or not. Now, given current interest rates, that is not very much money for a typical security deposit. I mean, we're really talking about dollars and cents, but you never know what might happen if there's another oil embargo or something and inflation shoots through the roof. It could be a significant amount of money. So be aware that you're entitled to that interest. Yes?
If you have a client that has, really bad credit, and as an incentive to get that landlord to lease that client up, can you offer a higher security deposit and not run afoul of, say, fair housing?
So there are limits on what can be demanded as a security deposit in DC. In fact, very strict and straightforward. It's 1 month's rent is the maximum security deposit. So you cannot pay a security deposit of 6 months' rent, say, with the understanding that you'll get it back at the end of your tenancy. Now, there is not, to my knowledge, an outright prohibition on prepaying rent or on paying rent in amounts other than monthly. So if there's a serious credit problem, but a tenant is highly liquid, they can prepay rent to make the landlord feel comfortable that they're going to maintain their obligations. Yes, in the back and then in the very back. Yes.
Let's say a landlord has an application fee of $50, but they also want $300 to hold the apartment for 15 days.
Yeah.
You don't have all your money together.
Got it. So we talked briefly about holding fees at the beginning. The thing I want to make people aware of is, from tenants' perspective, be very clear about whether the holding fee is refundable and under what circumstances. And though our orientation is pro-tenant, as landlords or realtors or whoever, be aware, the higher a holding fee you're asking for, and the less it is refundable kind of at the demand of the tenant, the more it starts to look like an option contract that will obligate you or your client to rent to this person when the terms that you've agreed to come to fruition, even if you later decide you don't want to. So be aware, the landlord may be obligating themselves to you by demanding a high holding fee. And yes. Yeah.
Yeah, let's ask a question. The security deposit. I had 2 instances where, the police broke down my door and accidentally gave wrong information given by the whatever. The other thing was the ICE agent did it shortly after that, because I was somebody who was illegal. Well, my question is, my landlord said she checked with both MPD and the ICE unit, but there was nothing put in writing saying that they were the ones responsible for breaking my door and for items in my apartment. So she's saying that she's classifying it as...
Okay, so again, I don't want to get needlessly specific, but if the issue is who's responsible for damages that are caused by third-party actors, by independent actors, it's going to depend on, it's going to be factual and it's going to depend on the language of the lease. The question is, who is assuming the risk? Generally speaking, the landlord continues to hold all the equity in the property. The landlord is the one who assumes the risk of things like tornadoes, hurricanes, acts of war, or boneheaded police kicking the door down. But a lease can shift burdens when it comes to kind of who is the insurer, who is the insured, who is responsible for certain types of damages. In residential leases, it would be highly unusual for a tenant to be responsible for the independent bad acts of another person. If your place was burned down by an arsonist or burglarized, for the tenant to be responsible for fixing the window. Now that doesn't mean the landlord's responsible for your property that was in there. As long as the landlord provides reasonably secure housing, the landlord's not your insurance company just because someone breaks in or something happens to your stuff. Yes, and then we gotta move on.
Okay, what about pet deposit? Would that be part of that first month's deposit?
So we've seen pet deposits many times. It's kind of a gray area because, as we said, the security deposit is capped at 1 month's rent, and yet pet deposits are a common addendum to leases. My best understanding of it at this point, the legality is certainly challengeable if it's truly a security deposit in addition to the security deposit. I have not seen a court that is interested in striking down a pet fee since it seems to serve a useful business purpose, and there's no problem with a non-refundable pet fee, and it kind of doesn't make sense to punish a landlord for demanding a refundable pet fee, but allowing a non-refundable pet fee. That doesn't seem to protect tenants. So that's where the state of the law is as far as I know on pet fees. So,
Real quick,
yeah.
it says here, interest-bearing account for the security deposit. Does that mean that when you get it back, you get the interest?
Yes, it means when you get it back, you get your interest back with the proviso that interest rates tend to be very low, and it's not required to be good interest rate. It can be a very small amount of money. Yeah, actually, let me qualify that. You only have to get, the landlord only has to provide you interest on your security deposit if you live there for longer than a year. Not if you're there for 6 months or 3 months. So the provisions for returning the security deposit. The landlord has 45 days from the date of move out. First of all, there's a move out, I just want to mention that within 3 days of move out, if the landlord's going to do a walkthrough to look at damages, they are supposed to allow you to attend the walkthrough with them. It's supposed to be scheduled within 3 days on either side of your move out. You have a right to be there. Now, the landlord doesn't have to do a walkthrough at all, but they are supposed to make a time available for you. Yeah.
45 days from the move out or the expiration of the lease?
It's 45 days from the end of your tenancy, which would be the later of the two, because if your lease is still running and you're still paying rent, you're still the tenant, whether you live there or not. Conversely, if you're living there, even if you're not supposed to be, you're continuing your tenancy, even if it's a holdover tenancy, so it's going to be the later of the two. 45 days from that day, they have to either return your full security deposit or get you an invoice that says what they're withholding money for. And if they send you a notice that they're withholding money, you have to get the balance within 30 days after that. Yeah.
So what is the landlord's responsibility with that 3-day thing? If a lot of tenants move out, maybe they're owed a security deposit, they don't let you know where they are, forwarding address, nothing.
So much like, as I was about to get to, a landlord who doesn't follow this timeline, say, they get the deposit to you on the they get the invoice to you on the 50th day, say, or they don't do the walkthrough. In some jurisdictions, that would prevent the landlord from withholding things from the security deposit. In DC, it doesn't. It just creates a kind of presumption in the mind of the judge, if it ends up in small claims court, that the landlord is not acting as a good actor. And so, for instance, if the landlord blows the timeline, or if the landlord refuses to do the walkthrough, the law doesn't say that anything necessarily happens. But what we have seen is that what happens is that the judge at small claims court says, well, this is somebody who wasn't interested in a fair process for figuring out what the damages were. I'm going to doubt what they tell me. And if they don't follow the timeline, the only effect in law is that it means that if the landlord has nothing else to say, you win the case by default if you bring a small claims case against it. But again, the real impact is that it makes the landlord think, this was somebody who wasn't interested in doing what they were obligated to do. Beware of rolling security deposits, and this is a common practice here, and it is a mess. And it is a mess for both landlords and tenants, but landlords don't seem to realize it. Rolling security deposits are where the landlord tells you, you're not going to pay your security deposit to me, you're going to pay it to the person who's moving out. And then when you move out, that next person who moves in needs to pay you their security deposit. The landlord is in essence trying to make you the person who's on the hook for waiting for the next person to show up, or they just don't want to bother with the security deposit. The important thing to realize about this demand for rolling security deposits is, regardless of who you pay the security deposit to, if the landlord demands you pay it to the next door neighbor, their cat, whoever, that's fine. You know, they can define the terms of payment, how they feel paid. Someone can demand that you pay them by tearing it up and throwing it in the ocean. They still owe you the security deposit back when you move out, regardless of what they had you do with it when you moved in. And so the reason this doesn't work out for landlords either is that eventually, at some point in the chain, some tenant says, no, I don't want to wait for the next person to show up or whatever. I want you to repay me my security deposit with interest. And the fact that this rolling security deposit thing has been going on does not protect the landlord from having to do that. All it does is make the records a mess when you get down to court and try to figure out what the heck the security deposit was. So just be aware of that. The landlord has to provide receipts. A lot of landlords, even large institutional landlords in DC, do not seem to realize this. In most circumstances, the landlord has to provide you with a receipt for your rent check or your rent. The receipt, there's not a formal form they have to use, there's just certain information that needs to be on it. It needs to state these things. The only circumstance where they don't have to give you a receipt is if you pay by check, which a lot of people do, and you don't owe anything. You're paid in full. In that case, your voided check is your receipt. That's fine. In any other circumstance, the landlord has to provide you a receipt, whether that's an automatic reply from your direct deposit, or whether that's something that they write on a piece of paper. You have to have something back acknowledging that you paid and acknowledging these things: the date, that it was for rent or the purpose, and the amount of any amount still due. Whether that's a maintenance fee, whether that's rent, whatever it is.
What about money orders?
Money orders are a fine way to pay your rent, but the landlord has to provide a receipt if they're demanding you pay by money order.
Because it's not a personal check.
Because it's not a personal check. The landlord can demand payment by money order, particularly if you've missed rent before. The landlord is allowed to kind of go from a situation where you were paying by personal check, if a check is bounced, and say from now on it's got to be money order, but they have to start giving you receipts at that point. Yeah.
Yeah, this was another thing I wanted to bring to the table. Well, over there where I live, when they do my money order, they be writing, I live on
So
Braden.
I'm not going to get into individual situations, ma'am, I'm sorry, but that's a highly individualized situation. It's about where you live and the practices of your
I was
landlord.
just gonna say about Breeden, the name of my street as VL, and I had to call it to her attention, don't do that, because there might be a street in District of Columbia called BL Street. So, that's the problem I've been having out there.
Okay, so I would suggest you bring that to the legal clinic if you have questions about that.
All right.
So, let's keep going. Rent control. And this is obviously a big one for a lot of people. And this is going to be the last topic, I believe, this afternoon before we take our break, before session 2. Rent control, the first important thing to understand about rent control is that it is an opt-out program in DC. The default is that the mentality of it is that all units in DC, residential rental units, are rent controlled unless they meet a certain list of criteria. Now, those listed criteria are pretty broad and actually encompass most of the rental housing in the city, but the orientation is still that you are